Greetings and welcome to Summary Judgment, condensed from American jurisprudence. And this is part 2, continuing from where we left off last time. I believe it was section 11. Before we get started, just to remind everyone, this is strictly for the entertainment and educational purposes of this YouTube channel broadcast, not to be used, misconstrued, abused, or misused for anything legal, lawful, personal, private, financial, tax, business, or otherwise. So please don't do this at home. That said, let's get started. So we left off on section 11 last time, and now we're going into section 12 here, generally with the nature and scope in general. So summary judgment is a procedural mechanism that allows parties to seek resolution of claims without a trial when there are no genuine disputes of material fact. So as we read under the federal rules and state statutes, parties may move for complete or partial summary judgment. The courts may grant a partial summary judgment even when complete judgment is requested. So that's at the discretion of the court. They don't necessarily have to grant the entire request, but they can do it in partial by their order. The court's discretion depends on specific circumstances of each case. And as we saw, the Federal Rule of Civil Procedure 56 governs summary judgment procedures. So the Federal Rule of Civil Procedure, Rule 56. State rules may vary, but they generally follow similar principles, if not identical to Rule 56. Defendant, here's our case. This is from In Re New Motor Vehicles Canadian Export Antitrust Litigation in District Court of Maine, 2005. This is from, by the way, an American Jurisprudence 2008 supplement, I believe. So these cases here are from 2008 and earlier. New cases probably are still out there. However, the general principles still apply, and I don't believe Rule 56 has been amended since then. But again, that's just we're just going over the basics and the fundamentals here. If you are interested, you just need to follow up with your current statutes, the current rules, and the current case holdings. Let's continue. Defendant was not entitled to final summary judgment motion at any time and without district court's permission in complex multi-district litigation. So the defendant was not entitled to file a summary judgment motion at any time and without district court's permission. But this is in a complex multi-district litigation. Rather, the district court had authority to adopt special procedures to manage litigation through, including limiting timing of summary adjudication that might otherwise exist under rule governing motions for summary judgment. So court discretion depends on specific circumstances. Let's proceed. So we're on to section 13, time to move. And by the way, if anyone just arrived, please hit the like. Make sure we get the notifications out there. They've been pretty thin lately. However, this should be a fun one because we'll have a special surprise at the end. So pay attention. Federal and state rules establish specific timing requirements for filing summary judgment motions, with variations depending on whether the party is seeking or defending against a claim. So, specific timing requirements will depend on whether the party is either seeking or defending a claim. And we have here that the Federal Rule of Civil Procedure, Rule 56, the movant, the one moving for summary judgment, may file after 20 days from the action commencement or an adverse party's motion. So they have to wait after they file 20 days from the commencement of the action, or if an adverse party files another motion. Defending party may move for summary judgment at any time, though, under federal rules. But some state rules require that issues be joined before a summary judgment motion. And a motion not premature.
Judgement says, didn't you already go over this exact video earlier?
No, this is a different one. This is part 2. We went over part 1 before, and we also covered the Federal Rule of Civil Procedure.
Judgement says, or is this a re-upload?
No, this is a new presentation here. So as we are going over this generally, there is kind of a little bit of an overlap. That's kind of a nature of American jurisprudence, to reinforce from many angles. So it's a multifaceted learning of how all these principles interrelate within a legal framework. So there might be some similarities in here, but I guarantee this is all new content, so pay attention. So Section 13, time to move. Federal and state rules establish specific timing. So the state rules require that issues be joined before summary judgment motion in those states. Then that would require a waiting time that might be outside of that federal Rule 56. Motion not premature due to incomplete discovery. So remedy is seeking continuance under a Rule 56. And summary judgment may be considered after a mistrial and before a new trial. So it may be considered. But the caution here is a pre-trial order limitation for filing motions for summary judgment is not a bar to later filing, because Rule 56B expressly authorizes the defending party to move at any time for summary judgment. So a pre-trial order limitation for filing motions is not a bar to the later filing. So at some point, the court would have to allow that summary judgment motion from the defending party. So let's see here. The motion, of course, not being premature due to incomplete discovery. As we saw, though, after a complete discovery, then after, 20 days, then it's not eligible for a summary judgment motion. The remedy is seeking a continuance under Rule 56B. In this case, when a motion is not premature due to incomplete discovery. So in that case, there might be reasons why there would be a continuance. But however, those are specific circumstances. Let's proceed with more for Section 13, time to move. The district court did not abuse its discretion in refusing to allow a plaintiff to file motion for summary judgment more than 9 months after deadline for filing dispositive motions. It did not abuse its discretion refusing this filing of the plaintiff to file a motion for summary judgment, even though the plaintiff claimed that the motion was late because he finally obtained eyewitness declaration corroborating his allegations. Finally, 9 months later, where plaintiff had earlier supplemented opposition to defendant's motion for summary judgment with declaration. So now he's got some eyewitness declarations, but the judge didn't buy it. Looks like district court did not abuse its discretion. Remember, they have discretion to allow for that motion for summary judgment. And that's in December 8, 2005. Defendant was not entitled to file summary judgment motion at any time and without district court's permission in the complex. We read this case here. This is in Ray, the New Motor Vehicles Canadian Export Antitrust Litigation. So we see here in complex.
Bill 4426 says, did we not have a 30-day minimum from final discovery to motion to dismiss in the last video?
No, the 30-day minimum was something else.
Bill 4426 says maximum rather.
I have to go back and check on that, but it was, there was a 30-day. Well, I know it's after discovery is complete, 20 days after discovery is complete. That's from this presentation here. The last one, I have to really think back exactly which limitation that was. If you want to give me a second, I could tell you right away. So as we're saying here, definitely check in with the thumbs up button there to make sure. See, that was in Section 1, right? And it was a 30-day. Let's see here. Was it from Rule 56? Possibly it could have been, because I think that's probably where we saw that. I'd have to pull up the Rule 56 and see if it's in that. I'm just checking here, see if I can scan through and find that 30-day on the other one. And I don't see it here. Okay, yep. So let's check out in Rule 56, which we have handy here. All right. So on Rule 56, give me a second here. There we go. Let's go back here to the beginning of it and see where we have that 30-day. Yep, here we go. Summary judgment is a procedural tool allowing courts to resolve cases without trial when there's no genuine dispute of material fact.
Bill Limit 4426 says, thanks for the review.
Yeah, indeed. We can't let things slip by. That's the whole purpose of doing these live streams. So appreciate that. Yeah, so anytime until 30 days after the close of discovery. But I saw somewhere we had 20 days. I think it was on this presentation here. Let's go back and check. Of course, when it comes to states and the federal rules, there's a lot of alignment, but sometimes there's not. So let's see here. Yeah, so I remember seeing a 20-day. Maybe that's coming up later in it. Here we go. The movement may file after 20. Okay, so that's the 20 days. The movement, typically here, the plaintiff, the one moving for summary judgment, may file after 20 days from the action commencement. Even the defending party, if they're moving for summary, it would have to file 20 days after the commencement or after the adverse party's motion. Then the defending party, the one defending against the motion for summary judgment, may move for summary judgment at any time. All right, so that's the 20 days there and the 30-day. So yes, we had a lot of confusion, but I'm glad we sorted that one out. One has to do with the discovery, making sure all the final discovery is all complete. And this is for the commencement of the action with the 20 days. So the 30 days involves discovery. The 20 days involves the commencement of the action. But we're not done with dates yet, so keep those in mind. Use those little memory aids there if you want. The discovery is later on. That's the longer date, 30 days, 20 days for the commencement of action before filing for a summary judgment. So let's continue with the time to move. Let's see, we get that slide. We're on to this one here. So this is in Gill versus Hoadley in the Northern District of New York in 2003. Affidavit submitted by corrections officials in inmate section 1983 action alleging violations of his free exercise rights under First Amendment warranted denial of his summary judgment motion as premature. The officials had not had sufficient opportunity for pretrial discovery as to circumstances surrounding inmates' request for permission to attend services, whether requests were timely and compliant with corrections policies, whether they were denied, and, if so, whether the denial was related to legitimate penological concerns. So they had to have that discovery before the summary judgment. Interesting there. And that's from the affidavit by the corrections officials. So see how this is done. This is key. It wasn't just an allegation, it was an affidavit. They didn't just say it's because of this. They have a sworn statement or an affirmation. Okay, now we have NAS Electronics Incorporated versus Transtech Electronics, PTE, and that's from the Southern District of New York, 2003 also. Plaintiff's motion for summary judgment was procedurally defective, where motion was filed after time for serving dispositive motions had passed, and plaintiffs failed to submit statement of undisputed facts. There it is. So, important to get that on the record timely. All right, now we're after the time, we are on to the successive motions. Section 14. Courts have varying approaches to allowing multiple summary judgment motions from the same party, with considerations for new evidence, clarification of law, and, of course, judicial discretion. So, additional motions allowed with new evidence not previously presented. The court may reconsider denied motion even without new evidentiary material, though. A second motion may be treated as reconsideration if law has been clarified. So the clarification of law there, it could be treated as a reconsideration. Different judge may not reconsider and grant summary judgment on the same issue. And a rule allowing defending parties to move at any time doesn't limit the number of motions. So that's an interesting one there too. Doesn't limit the number of motions. To the extent that plaintiff equipment supplier's motion seeking recovery of additional amounts from contractor after plaintiff obtained summary judgment holding contractor liable for majority of amount sought in action seeking reimbursement for liquidated damages paid by supplier to construction project owners was subsequent motion for summary judgment. Such motion was procedurally improper, okay, where supplier raised no new facts or arguments that it could not have raised in the first round of briefing, and other issues remained pending that would require further briefing or a trial. So, that's Siemens Westinghouse Power Company versus Dick Corporation in Southern District, New York, 2004. Interesting here that although you can have, it doesn't limit the number of motions, you definitely don't want to miss that first round, something you could have put there. There was nothing new in law, no new evidence, no new conclusion of law that couldn't have been raised in the first briefing. And you'll see this time and time again, that things will be denied later if they could have been raised in the first round. So important to keep that in mind. There are times where you might want to hold back, and there's times where you can't because it's too much of a risk. But that's neither here nor there. Let's continue here on to section 15, oral motions. There is judicial divergence.
Logic term says, or is this a re-upload?
No, not a re-upload, but it's somewhat familiar. As you saw, Bill Thomas is pulling up some of the numbers and dates where it starts to blur together a bit. This is all one section, though. We're all going over summary judgment. It was sections 1 through 11 in the first section. We're on section 15 right now. All right, so oral motions. There is judicial divergence regarding whether federal courts may grant summary judgment based on oral motions that are not in written form. Some courts have granted summary judgment upon oral motions. Some have. But other courts hold that Federal Rule of Civil Procedure 56 does not authorize oral motions. The written motion requirements serve procedural fairness, and oral motions may limit opposing parties' response time. These are common with any kind of pleadings. Local court rules often specify motion requirements. And our observation is, while some courts have allowed oral summary judgment motions, practitioners should always submit written motions to ensure compliance with procedural rules and provide adequate notice to opposing parties. As the maxim goes, the spoken word flies, the written letter remains. And onward to section 16, notice. Proper notice requirements are essential for summary judgment motions, ensuring parties have adequate time to respond and prepare opposing evidence. So, more dates to remember here. Federal Rule of Civil Procedure 56 requires 10 days notice before hearing. The judgment will be reversed without adequate notice to adverse party. The purpose is to allow reasonable opportunity to discover and submit opposing material, so that 10 days notice. General rule: deny motions with insufficient time and give them a leave to renew. A leave is permission to do something outside the normal rules, so you take a leave to renew. The exception is if argued on the merits with no prejudice and complete affidavit submitted. So that's your exception here. If it's argued on the merits with no prejudice and complete affidavits are submitted, then there could be an exception to notice. But typically, since it is not obvious to a layman, now this is a good one here. This is from, in fact, this is a very key case here too. This is Irby Irby versus New York City Transit Authority from 2nd District 2001. So take note of this one here. Since it is not obvious to a layman that when his opponent files a motion for summary judgment supported by affidavits, she must file her own affidavits contradicting his opponent if she wants to preserve factual issues for trial. Haha, see, key. It's not obvious, right? So, the fact that since it is not obvious to a layman that when his opponent files a motion for summary judgment supported by affidavits, that she must file her own affidavits contradicting the counter affidavits, his opponents, if she wants to preserve factual issues for trial. Either the district court or the moving party. Oh, look at this. Either the district court or the moving party is to supply the pro se litigant with notice of the requirements of the summary judgment rule. Key ruling here. Let's continue. And we continue with notice. The plaintiff was not entitled to conduct additional discovery before a court decided summary judgment motion, where he did not depose any witnesses until after discovery cutoff date had passed and he had been granted one
Must be
extension.
2001 says, Oakland Love.
Greetings, Less TV. Indeed. So, on this one here, this is Seidel versus All State Insurance in the Ninth Circuit 2001. So the plaintiff was not entitled to conduct additional discovery before the court decided summary judgment motion, where he did not depose any witnesses until after discovery cutoff date had passed, and he had been granted one extension. The plaintiff failed to provide affidavits setting forth particular facts expected from additional discovery. So dragging their feet there. And we have the one with Gonzalez Rivera versus Citibank, NA, and from 2003. For purposes of summary judgment motion, district court would consider from plaintiff's statement of uncontested facts only those facts with specific reference to record. Inasmuch as information in question was available to plaintiff had ample time to conduct discovery, and plaintiff could not excuse his failure to make specific references simply by stating he needed to conduct further discovery. So specific reasons, good cause, those kinds of things. Let's continue here. All right, we're on to section 17, the burden of proof. And this one will be a little extensive here because there's always burdens when we come with burdens of proof. The burden of proof in summary judgment motions requires the movant to demonstrate the absence of genuine issues of material fact and entitlement to judgment as a matter of law. So absence of facts in the matter of law. Movant must show no genuine issue of material facts exists. They must show this. It's a difficult one. All reasonable doubts resolved against the movant. The fact that it's hard to prove a negative like this, or almost impossible, means that it involves a presumption. So it's without a counter, a rebuttal against it, that would stand. The court would just, out of efficiency there, if there's no reason to go against the presumption would stand. So if the presumption's not rebutted, then it would just be accepted by the court. It could accept the fact that there are no genuine issues of material fact. All reasonable doubts resolved against the movant. So, again here, this is the burden of proof. All reasonable doubts resolved against the movant. If the burden's not met, the movant is not required to submit evidence. So the burden of proof. If the burden is not met, the movant is not required to submit evidence. Clarity is required, though. There's no room for controversy. It may prove essential element of opposing claim does not exist. So, again here, the hard part here is that the burden of proof in summary judgment motions requires the movant to demonstrate an absence of genuine issues of material fact, and entitlement to judgment as a matter of law. In our practice guide, we see that the showing required for summary judgment may be accomplished by proving that an essential element of the opposing party's claim does not exist, cannot be proven at trial, or would be barred by an affirmative defense, or by showing, through discovery, that the opposing party cannot produce evidence to support an essential element of his or her claim. So, critical practice guide here. Great tip. Let's proceed. A lot of cases here with burden of proof. As you'll see, the burden of proof shifts a lot. And I thought we had one here, another slide, but we'll probably get to that. Well, we'll see that how this is shifts. Whether the Title VII claims by class of Hispanic special agents for the United States Customs Service seeking class-wide relief for pattern and practice discrimination on basis of national origin could survive summary judgment did not depend on the named plaintiff's ability to state prima facie case. So this is interesting here. Let's see. Could survive summary judgment. Practice discrimination and did not depend on the named plaintiff's ability to state prima facie case. So this is an interesting one here too. Borrower's unsupported allegation that lender was not licensed to make loans in the state was insufficient to avoid summary judgment in lender's collection action, where lender provided court with certificate of compliance from state indicating that it was licensed to conduct business of premium finance in that state. That's from the AI Credit Corp versus Gores, and that's in Nevada, 2004. Let's see some more of these cases. Again, these are from a 2008 supplement. This one is Cloak versus West Claremont Local Schools District Board of Education in Ohio, Southern District, 2006. Party seeking summary judgment bears initial responsibility of informing district court of basis for its motion and identifying those portions of record which it believes demonstrates absence of genuine issue of material fact. Movement may do so by merely identifying non-moving parties' lack of evidence to support essential element of its case. So there it is. By merely identifying the non-moving party's lack of evidence to support an essential element. There it is, a key, essential element of its case. So important to see these two things. There's a lack of evidence supporting an essential element. And that merely identifying that would lift that burden of proof. So the movement for summary judgment has the initial burden. Here it is. Okay, so the movement for summary judgment has the initial burden of demonstrating the absence of genuine issues of material fact. And this burden may be discharged by showing that there is an absence of evidence to support the non-moving party's case. And once this burden is discharged, meaning no longer the obligation, that burden's no longer the obligation of that party, the non-movement must then establish the existence of each element on which it bears the burden of proof. So nice little, that's from Barrier versus Simplicity Corp. Not simple at all with shifting burdens. And that's the Eastern District of Pennsylvania, 2005. Let's continue with these cases for burden of proof. This one's from Alvarez versus Colin Matos in Puerto Rico, 2004. Puerto Rico Treasury agent's discovery, following denial of his motion for summary judgment in civil rights action rising from his warrantless licensing inspection of nightclub, of deposition that rendered nightclub owners' evidence contradictory as to agent responsible for the alleged violations, did not warrant reconsideration of the summary judgment motion after the jury returned verdict against the agent. Alleged contradiction would have precluded summary judgment, and agent had opportunity to present his full evidence before jury at trial. So there it is. We saw this before. If you don't get it the first round, you don't get a second chance. Unless there's new evidence. In deciding a motion for summary judgment, the trial court must view the evidence in light of the most favorable to the non-moving party. So the party, here it is, the party moving for summary judgment has the burden of showing the absence of any genuine issue of material fact and entitlement to judgment as a matter of law. And that's from Proventure versus Town of Enfield in looks like Connecticut, 2007. And here's one from Hartford, Indemnity Company and versus Ace American Reinsurance, 2007. And of course, Connecticut, right? In seeking summary judgment, the movement has the burden of showing the absence of any genuine issues as to all the material facts which, under applicable principles of substantive law, entitle him, the law entitles you to a judgment as a matter of law. So, no material facts.
4426 says, is a motion to dismiss asking for a summary judgment?
We're going to get into that distinction. I think we went over it before, or maybe we haven't yet, but yes, that's a clear distinction we're going to be covering. So, again, this is from that satisfy the burden in support of summary judgment. The movement must make a showing that it is quite clear what the truth is, and that excludes any real doubt as to the existence of any genuine issue of material fact. So, then you stick to the conclusions of law without the material facts. Then it's good for a summary judgment. I hate to really belabor going through so many cases, but however, it's good practice to do that. And when we're doing cases involving summary judgment, these are quick because there's no trial. There's not much to cover. So you really get the whole meat of how these cases are affecting the way courts rule, where their basis is in the law, how they're splitting hairs, how specific instances cause certain outcomes, and the way they're treated to give us a little bit of insight. And I think looking at these summary judgment cases is a way to go through a lot of cases rapidly and get the most out of all of them and how you apply them to the law. All right, let's continue down here. And this is Gray versus Stamford Health System, again in Connecticut, 2007. In deciding a motion for summary judgment, the trial court must view the evidence in light of the most favorable to the non-moving party. The party moving for summary judgment has a burden of showing absence of any genuine issue of material fact that the party is, therefore, entitled to a judgment as a matter of law. And we're on to another one here with Sewell versus Tribe Publications Incorporated. This is in Georgia, and let's see here, 2005. A defendant who will not bear the burden of proof at trial need only show an absence of evidence to support an essential element of the non-moving party's case. And if the movement for summary judgment discharges this burden, the non-moving party cannot rest on its pleadings, but rather must point to specific evidence giving rise to a triable issue. So that's a pretty interesting one there. Then we go to Todd Development Incorporated versus Morgan in Ohio Street. Yes, in Ohio, and that's 2008. The party moving for summary judgment bears the burden of establishing the lack of any triable issue. So no facts to try. If a moving party meets the standard for summary judgment required by the rules of civil procedure, and a non-moving party fails to respond with evidence of a genuine issue of material fact, the court does not err in granting summary judgment in favor of the moving party. So, non-moving party needs to respond with evidence of a genuine issue of material fact. That defeats the summary judgment motion. And burden of proof continued. Developers. This is on Todd Developer versus Morgan So same case, developers had the burden of producing enough evidence to show that there remained a genuine issue of material fact regarding their affirmative defenses to lot owners' claims that developers had violated covenants and committed trespass when responding to lot owners' motion for summary judgment. Wow. A plaintiff or a counterclaimant moving for summary judgment does not bear the initial burden of addressing the non-moving party's affirmative defenses. So that's interesting. A plaintiff or counterclaim moving for summary judgment does not bear the initial burden of addressing the non-moving party's affirmative defenses. Ooh. So then we go to Sinot versus Aqua Chemical Incorporated, well, Aqua Chem, and that's Ohio 2007. On motion for summary judgment, doubts must be resolved in favor of the non-moving party. To succeed in a motion for traditional summary judgment, a movement must establish that there is no genuine issue of material fact, so that the movement is entitled to judgment as a matter of law. So, common theme we've seen repeated over and over. And here we go. Furthermore, with a burden of proof, section 17. And this is from
Bill Timmons 4426 says examples help me remember the rules.
Absolutely, and this is the best way. These summary judgment cases, believe me, we're churning through them. We couldn't go through as many cases in this amount of time with any other issue, really, because these are all before trial. There's no trial involved in this. These are strictly matters of are facts present, and is there an entitlement by law for the summary judgment? Did it meet the requirements of the rule of procedure? These are the only things that we're really involved with. And other cases involve so many more, but the mechanisms are still the same. All right, let's proceed here. This is a Fort Worth Osteopathic Hospital, and this is Texas 204. And hey, here's our Four Brothers Boatworks versus Tesoro Petroleum Companies. All right, in deciding whether there is a disputed issue of material fact which precludes traditional summary judgment, every doubt must be resolved in favor of the non-movement, and evidence favorable to the non-movement must be taken as true. Ooh, wow, evidence. So, wow, look at that presumption. When a defendant moves for summary judgment on the affirmative defense of limitations, it has the burden to conclusively establish that defense, including the accrual date of the cause of action. Ooh. All right, so now we're on to the Jennings versus the City of Dallas and Texas Appellate.
J494 says, summary judgment is very involved, can be confusing.
Indeed, it can be confusing, but it's a lot less confusing than a trial. So think of it that way. Once you lick summary judgment, then a lot of these other things will be a lot easier to break apart because you can apply the same process to the more complex situations and be able to break them down similarly. So I think this is really a key to interpretation and application. With that said, let's continue here with this Jennings versus City of Dallas. Because sovereign immunity is an affirmative defense. A defendant alleging sovereign immunity in a summary judgment has the burden to establish all the elements of the defense as a matter of law. When there are cross motions for summary judgment, both parties are entitled to the benefit of all reasonable doubts and inferences. So, that's interesting there. Both parties are entitled to the benefit of all reasonable doubts and inferences. So think about that. The sovereign immunity is an affirmative defense. The defendant alleging sovereign immunity in a summary judgment has the burden to establish all the elements of the defense as a matter of law. So, interesting one there. A good one to note in those sovereign immunity cases. All right, we finally made it through the burden. Now we're going to get to shifting the burden. This is what I was thinking about here. We're going to get some good things that will help put it all together now. Section 18, shifting the burden to the party opposing the motion. Once the moving party meets the initial burden, as we just went over, of showing no genuine issue of material fact exists. The burden now shifts to the opposition to demonstrate that a genuine issue for trial does exist. So the burden shifts after the movement establishes an absence of genuine issues. Then the non-movement must show genuine issue of material fact exists. So we're going to see how to do these things. Non-movement must present specific evidence, not just speculation. So no unsupported speculation or conclusory allegations or improbable inferences. Non-movement must present specific evidence. Failure to meet burden results in summary judgment for movement. Cross motions. Both parties must meet the burden independently. So each cross movement for summary judgment bears the burden of establishing that no genuine issue of material fact exists and that it is entitled to a judgment as a matter of law. And the fact that one party fails to satisfy that burden does not automatically indicate that the opposing party has satisfied the burden and should be granted summary judgment on the motion. Now, that's an interesting one there. That's Klaus versus Rogel and Hamilton of Ohio, 2006, Southern District. Let's move along. So, continuing with shifting the burden to the party opposing the motion. Summary judgment opponent, after completion of sufficient discovery, must submit evidence in support of any material element or claim or defense at issue in a motion on which it could bear the burden of proof at trial, even if the moving party has not submitted evidence to negate the existence of that material fact. And that's from that Cloak versus West Claremont School District Board of Education. So that's an interesting one there. The summary judgment opponent, after completion of sufficient discovery, must submit evidence. So they must submit evidence in support of any material element of claim or defense at issue in motion which it could bear the burden of proof at trial. So those facts now need to be used as part of the against that summary judgment. So again, shifting that burden. Once that sufficient discovery, now they must submit evidence in support. So there's additional burdens now. The movement for summary judgment has the initial burden of demonstrating the absence of genuine issues of material fact. And this burden may be discharged by showing that there is an absence of evidence to support the non-moving party's case. And once this burden is discharged, the non-movement must establish the existence of each element on which it bears the burden of proof. So, I guess this is where the attack can be pretty broad, because if any of those elements can't be established, well, it looks like it says that the non-movement must establish the existence of each element on which it bears the burden of proof. Okay. Then when opposing motion for summary judgment, that's again from the Simplicity Court, Barrier versus Simplicity in Pennsylvania, 2005. And now we have a new one here, Underhill versus Thompson from Kansas 2007. When opposing a motion for summary judgment, the opponent must come forward with evidence to establish a dispute as to material fact. So one has a burden of proving there's no material facts, genuine material facts exist. Then the burden shifts to the other party to prove that they do. Again, with evidence, not speculation. And we're on to section 19, generally, with a motion to dismiss. This is what Bill Thomas, I believe, was asking about. Yes, there's a motion to dismiss asking for summary judgment. Well, this should answer it now. Motion to dismiss or for judgment on the pleadings as one for summary judgment. Well, under federal rules, motions to dismiss or for judgment on the pleadings may be converted into summary judgment motions when matters outside the pleadings are presented to the court. So, again, the pleadings probably involve a lot of facts, and things like that. But here, the facts wouldn't be relevant. It would be something where they're saying that there are no material facts. Motions converted when matters outside the pleadings are presented. The converted motions must meet Rule 56 requirements. So the Federal Rule 56 acceptable forms. Here are some of the ones. These are the matters outside the pleadings that are presented. Here are the acceptable forms. You have depositions, interrogatories, admissions, and of course, affidavits. Oral testimony, exhibits, and documents may also convert the motion. So these are the outside matters. Exhibits incorporated in pleadings do not convert the motion, so it has to be outside the pleadings. If there's an exhibit incorporated in the pleadings, then it cannot convert. So this is a motion to dismiss or for judgment on the pleadings converted into a summary judgment, meeting the rules of meeting Rule 56 requirements. Okay, so let's look into this a little bit deeper here. So generally, in doing this, is the plaintiff. Here's a Burnham versus Humphrey Hospitality Right Trust.
Bill Plymouth 4426 says, I understand this better now. Thanks.
Great. Well, we're still digging. We're still in Section 19. We're not done yet. Let's look at some of these cases here. And this one's from the 10th Circuit, 2005. Plaintiff was not prejudiced by district court's conversion of defendant's motion to dismiss into a motion for summary judgment by relying on materials outside the complaint, permitting Court of Appeals to review district court's grant of motion as a grant of summary judgment, although no notice was given, where plaintiff's opposition to motion to dismiss first introduced affidavits containing facts beyond those in the complaint, and defendants only introduced affidavits in their reply brief to counter those of plaintiff. So here's our caution. A motion to dismiss is not automatically transformed into a motion for summary judgment simply because matters outside the pleadings are filed with the court. The test is whether the court actually takes cognizance of the supplementary materials. So, interesting there. The decision to convert a motion into a motion for summary judgment takes place at the discretion of the court and at the time the court decides not to exclude the extraneous matters. So, it's discretionary. Key to know this, it's not a mandatory conversion. So let's look at some of these discretionary applications of that converting motion to dismiss or other motions on the pleadings to a motion for summary judgment. This is from Zink versus Slater and 10th Circuit, 2002. District Court did not convert defendant's motion to dismiss into a motion for summary judgment by considering matters outside the complaint. Defendant's motion to dismiss was based on lack of subject matter jurisdiction, not a failure to state a claim, and thus reference to evidence extraneous to the complaint was permitted.
Jack says they have to like folks. Jack says they have to like folks.
Yes, indeed. Greetings to you, Captain Jack. All right, so as we see here, reference to evidence extraneous to complaint was permitted without converting it into summary judgment, because the judges have discretion. Here, the Court of Appeals would treat dismissal of taking claim for lack of subject matter jurisdiction as a grant of summary judgment for government when ruling was based on conclusion that claimants had failed to identify factual issue precluding summary judgment, despite the lower court's characterization of dismissal. So the Court of Appeals would treat the dismissal, so even they converted it afterwards. And that's Federal Circuit. So yeah, 2005. So as we read before, that the federal courts could see this as changing an order from another court. They could convert this. I believe that's where that's coming from. Let's proceed. All right, so I hope we covered that part there with the motion to dismiss and summary judgment. Now we're on section 20, the necessity for notice and an opportunity to respond. When a motion to dismiss is converted into a summary judgment motion, parties should receive notice and a reasonable opportunity to present matters pertinent to the summary judgment. So a notice is required when the motion is converted to summary judgment. It gives a reasonable opportunity to present relevant evidence. Failure to give notice may be a harmless error, though. Error is not prejudicial if dismissal proper without extra pleading material. So, if dismissal was proper without extra pleading material, the error is not prejudicial because, again, the dismissal would be proper. And a waiver of notice if party fails to object to lack of notice. So let's look here for the Cost versus Young Men's Christian Association, so YMCA of Metropolitan Minneapolis in Minnesota 2007. Motion to dismiss could be converted into one for summary judgment without giving notice to the parties where it was the non-moving party who has submitted materials outside the pleadings. Okay, so they're the ones that started it with submitting the outside parties, the non-moving party. So then that would be the one that could have, they're not really entitled to notice, it seems, at least in this situation it wasn't. So I guess beware if you're going to be that involved with it. Keep notice of the docket, huh? All right. Let's see here. Here we go. Okay, continue with section 20 here. This one here is from Judgement versus City of New Rochelle, New York in 2003, Southern District. Motion to dismiss African American city employees' race discrimination suit by city and its officials would be converted to motion for summary judgment. As employee had requisite notice that defendants were alternatively seeking summary judgment, and employee expressly discussed facts that went beyond allegations contained in complaint in his opposition to defendant's motion. Expressly discussed the facts. Yeah, be careful what you say. Yeah. See where that got him. So, Sweet versus Wen Correctional Facility, and this is Western District of New York, 2003. For plaintiff to successfully oppose a summary judgment on the basis of need for further time to conduct discovery, he must explain the nature of the uncompleted discovery, how the facts sought are reasonably expected to create a genuine issue of material fact, what efforts the plaintiff has made to obtain those facts, and why those efforts were unsuccessful. So, yeah, you better come with the facts. All right, we're on to section 21, the amount and type of notice, the nature and scope in general. Federal and state rules establish specific notice requirements when a motion to dismiss is converted into a summary judgment motion. Okay, here we are again. The federal rules, 10 days notice required for the summary judgment, same as before. But take note here, the federal rules are 10 days notice, but some state rules, 14 days notice is required. Not sure what states, check with your jurisdiction, but typically 10 days. I'd stick with the 10 days, 14 days, I guess, in your state. If that's what that is, better to give better notice. That way you cover both bases. But I believe the 10 would be the standard. Same notice period applies when motion is converted, as we saw before. And notice period begins when conversion is determined. Failure to provide adequate notice may be a reversible error. It's not one for appeal, it's reversible. And section 21, the amount and type of notice continued here. This is in Sweet again versus the Wendy Correctional Facility. For plaintiffs to successfully oppose summary judgment on the basis of need to further time to conduct discovery, he must explain the nature of the uncompleted discovery, how the facts are sought, are reasonably expected. Now we got this one already, and why those efforts were unsuccessful. Okay, so caution, the notice of conversion of a motion for dismissal into motion for summary judgment need not be explicit. So the notice doesn't need to be explicit. It is adequate if the non-moving party is fairly apprised before the hearing that the court will look beyond the pleadings. So, interpret that as you may. But that takes us to the fun part now. We get to the end with the summary judgment quiz. Let's test your knowledge and see how well you all remembered everything we went through here. Let's start with question 1 under the Federal Rule of Civil Procedure 56. When may a party defending against a claim move for summary judgment? So we have A, and by the way, when you answer in the chat, just put the question number 1 and then the letter of your chosen answer. So under Federal Rule of Procedure 56, when may a party defending against a claim move for summary judgment? So you're defending against a claim. When can the party that's defending against a claim move? Only after 20 days of commencement? B, at any time? C, only after discovery is complete? Or D, only with court permission? All right, this is a pretty easy one here. See if anyone can get it. Go ahead and pipe up in the chat, and we'll move on to the next one here. Special prize at the end.
Bill Plymouth 4426 says 1, capital A.
All right, you're choosing A. We've been talking a lot about dates, but remember, we're talking about the party defending against a claim, not the one making the claim. So you're defending against a claim. When can they make a move for summary judgment? All right, let's go on to question 2. What happens when
Facetious Expert 587 says C.
Greetings to you. Is that for question 1 you're saying? You got to put a number in there before I take the answer as a final. But let's go to question 2 while you figure that one out. What happens when a motion to dismiss is converted into a motion?
Auditum says 1B.
All right, Auditum says 1B. Okay, we got you noted. So on question 2, what happens when a motion to dismiss?
Jacob Jack says, I don't guess.
That's right. So put your affirmative answer in, and we'll assess it very soon. So question 2, what happens when the motion to dismiss is converted into a motion for summary judgment? A, notice requirements are waived. B, Rule 56 requirements apply. C, case is automatically dismissed. Or D, discovery is automatically extended. All right, guys, this should be an easy one here. So what happens when the motion to dismiss is converted into a motion for summary judgment? We dove deep into this one. So is it A, notice requirements are waived? B, Rule 56 requirements apply now with a conversion? C, case is automatically dismissed? Or D,
Facetious Expert 587 says 2B.
2B or not 2B? Okay, we'll put you down for 2B. All right. Any more takers? Go ahead and put them in. We're going to move on to the next questions. Next set of questions. Here's question 3. This is a good one here. What burden must a movant meet to obtain a summary judgment? You're the party moving for summary judgment, the movant. What burden must...
says 2B.
Yes, okay. We got 2B down, 2 for 2B. All right, now on question...
Bill Plymouth 4426 says, I thought I understood. Now I am not so sure.
No, that's good, because now you're getting down to the finer distinctions, which really brings you to the complete understanding, not just a cursory.
Facetious Expert 587 says 3B.
All right, so we got a lot of takers for 3B. Oh, that was 3B. Okay, so I haven't even read this one yet. So let's see here. What burden must a movant meet to obtain summary judgment? A, a preponderance of evidence. B, no genuine issue of material fact. C, clear and convincing evidence. Or D, complete discovery. And Facetious Expert already put in B here for his choice. And we're going to move on. Question 4. Any other takers for question 3? Go ahead and pipe it up in the chat. So for question 4.
Bill Plymouth 4426 says 3B.
All right. So
Auditum says 3B.
Looks like we got a pretty good consensus.
Jeng 494 says, capital B.
Capital B. That sounds definitely authoritative there and with confidence. Okay, so question 4 now. How much notice is required? Okay, this is a good one, especially for Bill Thomas. I hope you were paying close attention. How much notice is required when a motion to dismiss is converted to a summary judgment? This is a tricky question here. A is 5 days, B 7 days, C is 10 days, and D is 14 days. Any takers on question 4? How much notice is notice? Now, this is sending notice is required when the motion dismissed is converted. As soon as it's converted, then there's a notice due. How many days before the hearing? So 5 days, 7, 10, or 14. So this is converting it. How much notice is needed? So
Jeng 494 says, capital C.
All right. 10 days. Okay. So any other takers on question 4?
Facetious Expert 587 says 4D.
All right, and you choose D. So let's see what we got here. Any other takers on question 4? And we're going to move on to the answers. All right, and here we go. All right, so now we get to the answers. For question 1, when may a party defending against a claim move for summary judgment? The answer was B for question 1, at any time. As we see here, Federal Rule of Civil Procedure 56B allows defending parties to move at any time, providing flexibility regardless of timing. All right, now on to question 2. What happens when a motion to dismiss is converted into a motion for summary judgment? As we saw, the Rule 56 requirements apply. In whatever state it is, they would be conformed to Rule 56, if not identical. The explanation is when matters outside pleadings are presented, the motion is treated as one for summary judgment under Rule 56. And with that, we move to question 3. What burden must a movement meet to obtain summary judgment? And we got a good consensus on this one. The answer was B. No genuine.
Says BBBC is the answer.
Yes, you got it. That's the answer for all of them, but a little late now. Okay, so on question 3, we have what burden must a movement meet, and we all had a consensus that no genuine issue of material fact. The explanation here is the movement must show absence of genuine issues of material fact, with all doubts resolved against movement, as stated in section 17, as we read. And finally, on to question 4, which was a bit of a trick question here, and I'll get into that, but how much notice is required when a motion to dismiss is converted to a summary judgment? The answer was C, 10 days, according to the Rules of Civil Procedure 56. But the federal rules required 10 days notice when a motion is converted to summary judgment, as stated in Section 21. However, we go back to Section 21. Notice this. Here we go. Federal rules, 10 days notice required for summary judgment. However, some state rules, 14 days notice required. So be careful. Make sure that you always check with local and state rules. You can't just only go by the federal rules, though most of the time they're going to apply, practically all the time. But some states have other rules. This is one where they will. So take note with summary judgment to also look at state rules involving any of the conversions of summary judgment from motion to dismiss to a summary judgment. So there it is. We've got the quiz answers here. You all did excellent, and I think that we had the dual answers for question 4, so both of those will be considered correct. Let me double check over here. I saw that we had a, no, that wasn't 4. Here we go. Here we go. Jeng 494 has C, which is also correct. And let's see. Yep. It's not just, wait, that's 4. There's another one here. So here we go. This one here is the one. We had B, which was also the 14 days, I believe.
Bill Thimmett 4426 says, I learned motion only lack the students that to prove it.
Yeah, exactly. All right, so there it is. I think we get it down there. I'm confusing myself here with the make sure you put the number along with answers in the future, so I get easily confused with that. But that said, I think we had a pretty fun little quiz here, and stick around because we're going to have furthermore to go with the summary judgment. This is only part 2. I think there might be a couple more parts left, but I'm trying to keep them in small, manageable chunks so we could go by and take some of these little points out of it that can really stick in with the memory. Again, issues of genuine material facts really stands out, and the shifting of burdens. Once those there's an absence of fact that can be somewhat shown with some evidence, that the next step is that the other party now has to show that a fact does exist. So when no genuine fact exists as being alleged, the next party has to show some substantive.
James 494 says, these summary judgment videos were awesome. Tribe, thank you.
Oh, you're very welcome. And I thank you all for attending and making it fun. And there's more to come. So please hit the like if you did have a good time. And we're going to be moving on to more summary judgment coming up soon. So that said, I salute you all for being here and learning along with me. And I hope to see you all on the next one. Peace out.
Bill Thimmett 4426 says, take care all.